with either of you before, so I'd like to begin by just giving a little background on myself and then hear from everybody here so I get to know you a little bit. I've been mediating full-time with Resolve for the last several years. Before that, I was a trial lawyer for about 7 years. I teach part-time as an adjunct faculty at one of the law schools in Chicago. And much of my work is injury-related, tort and liability work. And I'm very happy to be with you here this morning.
Okay. I've been practicing law for about 8 years, predominantly personal injury plaintiffs' work. So this is pretty much right up my...
National Bank here in the city, and I'm here on behalf of my daughter, Laura, who was injured in an automobile accident.
Okay, thank you.
I'm a casualty claim representative. I've been doing that for 5 years. I specialize in bodily injury.
Okay. Now, as I understand it, Tom, you and Jim have worked together on some cases in the past, so you don't need to be introduced to each other.
Right.
Okay. Let me explain to you very briefly what the rules of mediation are. It's very simple. It's intended to be a very casual, candid, open discussion. We like to get to the heart of the matter as quickly as we can, so I want to encourage you to try to get to the point, but to listen very carefully to each other, and simply not to interrupt when I'm hearing from each of you, if you can follow that.
Okay.
I know sometimes emotions get involved and we want to get to the point, but we listen very carefully. I think we can learn a great deal about each other's perspective, and that's really the purpose here.
Okay.
Each of you has signed an agreement called Guidelines for Mediation, and let me just simply remind you that in the guidelines, each side indicated that you were coming here with full authority to settle the case. Tom, you have authority from your office to settle this morning?
Well, my authority is limited. However, I feel that I do have the amount of dollars needed to bring this case to conclusion unless I hear something totally unexpected.
Well, I guess what I'm hearing right now kind of bothers me because I've gotten that line before that I have what I think is enough, but it really isn't enough. As you, I'm sure, will hear when you hear where we're at in this case.
Well, Tom, if it turns out you discover something this morning you didn't know about before that changes your valuation of the case, and I should point out that usually happens. We come into the process knowing 50% but not 100% of what we need to know. If you find out something that changes your valuation of the case, I assume that getting additional authority, if that's necessary, is just a phone call away.
That's no problem at all, but in review of this case, I don't see this as a big case, and I hopefully will be able to come to some type of conclusion today.
All right. Does either of you see any reason the case cannot be settled today?
No.
Well, assuming we come up with the right dollar figures, I think it could be settled today.
Okay, good. Well, let me just point out a couple of other provisions of the Guidelines for Mediation. As everybody understands, this process is entirely confidential. None of the information disclosed here today is to be used in connection with litigation should a lawsuit be filed. And you have agreed not to subpoena my records in the context of any lawsuit. You understand that?
Yes.
And as well, and I want to remind you of this again, the process is entirely voluntary. I'm not here to make a decision to break the impasse. I'm afraid the hard work still belongs to you. I have no authority to render a decision or even to evaluate the case. If at any point you feel you're not making progress, let me know. You're free to leave at any point. It's entirely voluntary. As we move along in the process, I'd like to start off, Jim, by hearing from you on your understanding of the case. Give me some factual background, whatever you think I need to know about. As you know, I really know practically nothing about the facts of the case, other than that you're both prepared to work towards settling it. And then, Jim, after you've spoken, I'd like to hear from you, Mrs. Wickens, to explain to me, on a more personal note, what happened.
Okay.
And then when you've completed your presentation, Tom, I'd like to hear from you. When we finish that, I will caucus privately with each side. Now, a caucus is simply a confidential, private meeting. I want you to be as candid as you possibly can be with me in the caucus, and I will not be disclosing information to the other party after the caucus. Again, everything that's said to me is confidential, and unless you instruct me otherwise, I won't be telling the other party what happened during the caucus.
Okay, I have one question. If we do reach an impasse, are you going to tell us what you think we should settle at?
No, you both have been in this business long enough to have a very good sense of what a case is worth, and I want to encourage you to use your own judgment. At no point am I going to try to second-guess what you think this case is worth.
Okay.
I'm confident that we can make some very good progress this morning. If not, get the case settled. That's entirely in your hands, though. It's not always easy. It's going to take a little bit of work, but that's your job. My job is simply to help you reach agreement, not to tell you what the agreement ought to be.
Okay.
Okay?
Yeah.
All right. Well, Jim, I'd like to start with you and have you educate me as to the background of the case, what happened, and how you've reached your own judgment of what the case is worth.
Okay. Just...
Thank you, Jim. Let me see if I understand basically what the facts are, and I'll probably leave some things out and tell me if they're significant. But in September of '86, your daughter, Mrs. Wickens, was leaving school and got struck by a car. I guess there's a liability question as to whether she was in the place she was supposed to be, or whether the driver was exceeding the speed limit, and I'm sure we'll hear from Tom on some of those issues. She was injured and spent 30 days in the hospital, and what were the medical specials on that?
The medical specials were...
Of payment. Do you want to make that offer now? Do you have something in mind?
Yes, I do. Upon review of the file and the medical expenses that Laura did incur, at this point we would be willing to offer a total of $7,000 for this claim.
All right. And Jim, your demand was what? $75,000?
Coming in, it was $75,000, that's correct.
I want to thank you, Tom, for your presentation. Both sides have been very clear today. It's obvious that if this case does get filed in court and does go to trial, it's going to make for a very interesting and hotly contested dispute. And it's clear we've got two sides to this case. But what I'd like to do now is to meet privately with each side and talk to you about where you think we might be able to go today. Tom, if you wouldn't mind going down to the reception area and helping yourself to some coffee. My favorite edition of Life magazine is down there, and you can get comfortable with that for a few minutes while I talk to Mrs. Wickens and to Jim. That'd be all right?
That'd be fine.
Okay, thank you. Let me move a little bit over here. I can see we've got our work cut out for us. $7,000 and $75,000 leaves a little room for movement. Where do you think we're headed?
I'm really angry. I think that $7,000 is a slap in the face, considering what my daughter has been through. It's been traumatic, as well as for myself.
I have to agree. $7,000 is essentially no offer at all. He's come in essentially at zero again, because $7,000 with my fee out of it and with the $4,500 in medicals leaves nothing for my clients. And that's the bottom line that we have to deal with here. I cannot, in good faith, tell her to take $7,000 because it results in nothing. So I don't think he's come in with an offer yet.
Well, do you think he's going to be moving at all?
I would suspect and I would hope that he would move, because obviously if he doesn't move, we're all going home early.
Okay. Well, let me explain to you what I think we can accomplish here. The object of this process at this point is to make whatever movement you think is going to induce Tom to extend his offer as far as he can go. So what you need to be thinking about is what movement you can make from $75,000, if you can make a movement, is going to induce him to move up substantially. What do you think that might be?
Well, we have discussed this beforehand, and I have told Mrs. Wickens that we have to make moves from $75,000, and that realistically we were never going to get $75,000 in this case. I can move down at this point, and assuming that there will be some movement on the other side, I can move down $15,000 to $20,000. That's the ballpark of $55,000 to $60,000. But I hesitate to move beyond that unless I get some reciprocal movement.
And you think he'll see that as a pretty substantial movement on your part?
I would hope so, because I feel it is a very substantial move.
Okay. Well, let me ask you where you think, if we can think ahead a couple of steps here, where ultimately do you think Tom is going to come out? Where do you think the most amount of money is going to be that he's going to offer to you?
It's hard to predict what the most amount is. I would suspect that he's evaluated it at approximately 3 times medicals. Simple multiplication that insurance adjusters occasionally do, and that puts it at about $13,500. He'll probably come in somewhere above that.
Okay. So, and you think a move to a range of around 50 to 60 is going to get him to move up within that range?
I would hope so. I would hope so, because I cannot in good faith sit here and just move down and down and down until he decides to move up.
Right. Well, the ball will be in his court once you've made your move, and you'll find out really where he is headed, I hope. The object here is for both parties to make as much movement as they're capable of making at the table rather than to go to trial. So even if the case doesn't settle, we want both of you to be at sort of the outer reaches of how far you can move.
Okay.
Well, let me talk to Tom in a caucus and see where he feels he's headed, and then we'll all get back together again.
Okay.
All right, good, thanks. Let me first ask you where you think ultimately they may be willing to move.
Well, I tell you, in reviewing what they've done in the past, starting at $75,000, I am concerned. I'm hopeful that they will come down. The way I look at it right now, with Mrs. Wickens basically being in control, I hope they can get down to $25,000. I'm not going to go that high. I don't feel this case is valued that high. But I feel that he might get down to a point to get to $25,000.
Okay. I've asked them to seriously consider making some movement, so when we get back together again, we can get the ball rolling. What kind of movement from their part would be an indication to you that they're serious about moving the case along?
Well, they're at $75,000 again. If they don't come down at least 30, we've got to do some serious talking, because again, I'd like to get this thing resolved today, but we've got to see some movement, because we're nowhere near a close settlement. I think that he's way out of line in his initial demand of $75,000. I feel that we fairly evaluated the claim, and I really feel that the $7,000 is more within the range of settlement.
So you'd like to see him move down to $50,000 or maybe a little more than that. If he moves within that range, what do you think your next move might be?
Well, I guess I would be willing to go to $95 for settlement.
$9,500.
$9,500. Again, going over the facts of the acts, and I feel pretty strongly, our position, having evaluated it, and wanting to get to the table today to make some movement to conclusion of this claim.
Okay. Well, just keep in the back of your mind, I really don't know where they're going to come in. We talked generally about it.
Did they lower their demand during your caucus with them?
Well, I think they're prepared to make some movement.
Okay.
Basically, they're interested in settling the case, same as you are. I think both sides are interested in seeing an indication of some real good faith movement on each other's part, and that's the kind of thing that wins movement, actually. If they move, you move, and vice versa. So what you might want to think is, how much movement can you make to get them to move the maximum amount?
Okay.
But let's see what happens when they come back, and we'll take it from there.
Okay, real good.
Okay, good.
An independent witness, sure, but the person's been in left field and been in right field, and I don't think the jury's going to believe word one out of that independent witness.
Well, let me intervene here if I can.
Okay.
I mean, we could go back through and reevaluate the liability issues, but I think you're both pretty well aware of those. And what I basically want each of you to do is to do exactly what you've just done, which is to remind each other of some of the concerns that you have that you think make the case look very different. But what I'd like to suggest is that we break again. Both sides have made some substantial movement here, substantial certainly from the perspective of where you started, and I'd like to talk to each of you again about where you think we might be able to go. Does that sound fair?
Sounds good.
All right, why don't we do that, and we might as well stay in the same order. Tom, if you wouldn't mind going out and getting a little more coffee. As you know, I've spoken with Jim and with his client about getting some movement, and we're obviously still fairly far apart on this. And I've asked them to take a serious second look at where they're going on making some movement here. And I want to ask you to do the same thing. There's still a lot of work that we've got ahead of ourselves unless we quickly turn the corner and get into the range.
Well, I guess I have some concerns in regards to the dealings so far. Basically, I felt that in review of the entire situation, we're going to get close with that type of ideas in settling this.
Well, let me ask you this. If you go to trial, if you're not able to establish any contributory negligence, if the jury overlooks that, what is your possible exposure? Give me an idea of what the range is in your view if it goes to trial.
The range, if we go to trial, I'd probably look at this between 15,000 to 20,000 tops.
Okay.
Okay? That's the way I honestly feel in closely scrutinizing the information that we've got. I just feel that 20,000 would be tops for a jury award.
All right. Well, you're at 9,500 now. What can you do to inspire him to move?
Well, again, the dollars are limited. And I tell you, I've made a good faith effort in coming here today and in trying to get this situation resolved. I will tell you this, that I will go out on a limb if we feel close that to get some movement, that I will go to 14.
Okay.
But I mean, I tell you, that is, getting close to penny pinching.
Okay.
Because again, once I get to that point,
Jim, I know you've been speaking with your client about what kind of movement you feel you can make, and I'd like to have you present that if you would.
From our last caucus, we came down another 20, it came down to 35,000. And that's pretty much where we're at the end of that caucus. What kind of money do you have right now, Tom?
well, in review of the situation and in attempts to get this thing moving, I'm going to be going out on a limb, but I will increase our offer to $14,000.
All right, I appreciate that. I don't think 14 is going to settle it, understanding that I don't think 35 is going to settle it. But with all the movement we've had, hopefully we can settle it now. I talked to her in the break while you were caucusing, and I can bring it down. I think what she's looking for is the magic 5 figures. She wants to have for her daughter to put in trust $10,000. Now, this is a big move for me. That gets us down to about $22,000. I think the exact number is $21,750. After the fee and everything, that gets her $10,000. And I'm getting to the point with her that she's going to be hard to move off that. I may be able to move her, or I may be able to play with the number somewhere else, either in the medicals or my fee. The last place I really want to go, but that's where I can go right now, is at $22,000 or in that area.
Okay, again, as I explained to Brian in our last caucus, I wanted to make an attempt to see if we could get this settled to date. That's why I basically did go out on a limb from the $9,500 up to the $14,000 in an attempt to cut through some of this stuff so that we can get at what the dollar figures are going to be to settle it.
It really gets difficult, and you begin to think in smaller and smaller increments of movement. But let me remind you both of something, and that is how incredibly subjective necessarily this process has to be. I have found in talking with trial lawyers and seasoned adjusters like yourself that nobody is accurate within a range of less than 25%. And when I see parties who've made as much movement as both sides have, you're now at 14 and you're at 22, that there's a margin of error even with those final figures. And the margin of error that I have found usually prevails is certainly no less than 25%. And while you were talking, I was doing some calculations here. And if 14,000 was your final position, if you add 25% of 14,000 to that, you come up with $17,500, which would be, if your 14 was your best estimate of your exposure, that would be your range. And if 22,000 were your final position, Jim, reducing that by 25% would leave you at $16,500. So just in terms of knowing what an objective range is, you're actually within that right now, just to keep things in perspective. I don't know if either of you is prepared to move that much, but just in terms of your certainty of your movement, you may both have a little bit more. Certainty of your movement, you may both have a little bit more. I don't know if either of you is prepared to move that much, but just in terms of your certainty of your movement, you may both have a little bit more.
Well, if we can get to a point between somewhere around that 17.5 figure, I can present that to her, and I may be able to sell it to her. So if we're talking 17.5 right now, you know, I can take that to her if I can have that. I don't know if you can give that to me or if you have to make a call to do it, but I will present the 17.5, and I think at this point I could recommend the 17.5.
Well, reviewing the information that you have given us in regards to the 25% situation, to be honest with you, I was here today with a top dollar figure right around at $14,000. But to get the thing off the table, to get it signed and taken care of today, I'll go to the 16. But I'm going to the wall for that. I want you to know that basically I've exceeded my limit, and but in order to get this thing moving, I will go to that 16.
Okay, I guess we've both come to an impasse not very far apart. Can I split the difference on it with you? I was at 17.5, you were at 16. Can we say 16,750 and go home and close the files?
Again, I just went 2,000 on you right there to 16. As I indicated before, you know, I had a top dollar figure of right around that $14,000 mark for settlement of this claim. I went to the 16. I could go, and this would be it, just to get it signed today, I would go to 16.5.
Well, I'm not going to argue over $250. I'll take 16.5 to her. I'll recommend it to her, and hopefully it'll be settled. But I have to go talk to her, okay?
Okay, that'd be fine.
Okay, good. Well, if you'd go down to the reception area, Jim, and talk to her, I'll just wait here with Tom, and if you feel we're making some progress, maybe you could bring her back up with you.
Well, can we settle this today?
Yeah, we can. We talked it over, and I think it's a good settlement. It's not exactly what we were looking for when we came in, but I'm sure you feel the same way. We've both come a long distance. We've saved ourselves some time in court, I'm sure, and, you know, it's good. I really enjoyed this, and it worked out well.
Good. I agree. I thought we were at an impasse, almost, but we tried to avoid that in working together. Now let's see what we can do to wrap this thing up.